Greetings, everybody. My name is Eric D. Johnson, better known as Bright Shine. You know, this is okay. The purpose of this video, I just did video number 33. My indictments. My first indictment, 1994, and my last indictment in 1996. In this video, I'm going to show my petition for post-conviction relief. In the criminal court for Shelby County in Memphis, Tennessee, Eric Johnson, petitioner versus State of Tennessee, respondent. Indictments number 94-033857 and 94-033858. Post-conviction cause number P16501. Division number 10. File 2/28/1996. Petition for post-conviction relief. I'm not gonna try to. It's a lot of pages. Okay, I'm gonna read it. Pursuant to Tennessee Code Annotated, Title 40, Chapter 30, Section 201, Petitioner Eric Johnson, pro se, petition this honorable court for post-conviction relief, and respectfully show unto as follows. Okay, I'm gonna read a little of the preliminary statements. Eric Johnson, who will be referred to as the petitioner throughout the completionary of this cause, is an inmate of the Tennessee Department of Correction, currently housed at the Lake County Regional Correctional Facility. The petitioner submits further that he is currently being restrained of his liberty in violation of the 6th and 14th Amendments to the United States Constitution by virtue of the ineffective assistance of counsel. Okay. Okay, so here the petitioner conceded that he entered his plea of guilty for 15 years on April 10, 1995. That this is his first application for post-conviction relief. Petitioner had filed a memorandum of support of his petition. That there are no other appeals for relief in state or federal court for relief. And that the petitioner is without counsel and has filed a motion for appointment of counsel. The application to proceed as an indigent person and a motion for evidentiary hearing in order of transfer in this cause. Okay, it can't be too long with it. Okay, I'm just gonna summarize. Okay, procedural history. Okay. Okay. Procedural history. On or about May 13, 1990, the petitioner was arrested by the Shelby County Police Department. Shortly thereafter, a grand jury for Shelby County returned indictments against the petitioner, 1 count for aggravated rape and 1 count for rape of a child. Thus, the petitioner never had a preliminary hearing for said offense. On or about May 1994, the petition appeared before the criminal court of Shelby County for arraignment, represented by retained counsel. Let me see. Okay, it says here, okay. Represented by retained counsel, Mr. Stephen Schrader. Mr. Stephen Schrader. And then it says here, shortly thereafter, the petitioner reappeared before the court, represented by another retained counsel, Attorney Leslie Bannon, and entered a plea of guilty for 15 years. And as such, judgment was entered and the petition was transferred to the Tennessee Department of Corrections. We got some factual allegations. I'm not going to read all that, it's too long. Okay, I'm going to read this relief. Wherefore petitioner prays that the court grant petitioner relief to which petitioner may be entitled in this proceeding. Okay, it says here, premise to consider. The petitioner has submitted all grounds for relief in his memorandum of law in support of his petition for post-conviction relief, that there are no other actions in state or federal court pursuant to this cause. The petitioner has no further sentences to serve after he completes the sentence under attack. It was executed February 7, 1996. Memorandum of law in support. Petitioner presents a memorandum of law in support of his petition for post-conviction relief and sets forth the following grounds for relief. Introduction and operative facts. Even so, ground 2 and ground 3 are closely related. There are two separate issues. A letter from petitioner's attorney is attached to this memorandum and submitted as evidence to support ground 3. Okay, I'm going to read ground 1. Excuse me. I'm going to read ground 1. Ground 1. Whether the petitioner was denied the effective assistance of counsel guaranteed by the 6th Amendment and due process under the 14th Amendment when counsel fails to investigate his case. Ground 2. Whether the petitioner plea was voluntarily, knowingly, and constitutionally obtained when counsel failed to explain the nature of the charge that he was pleading guilty to. Ground 3. Whether the petitioner was denied the effective assistance of counsel guaranteed by the 6th Amendment due process and equal protection clause under the 14th Amendment to the United States Constitution when counsel failed to inform the petitioner that he would be ineligible for parole and or incorrectly inform the petitioner that he would have the opportunity for parole. Factual statement. Prior to trial, counsel informed the petitioner that he had arranged a plea bargain with the state that if the petitioner pleaded guilty, he would receive a 15-year sentence to be served at 30% before parole eligibility. However, the crime that the petitioner was pleading guilty to were crimes that carried a mandatory sentence. TCA 39-13-5-23. Multiple rapists, child rapists, sentencing, release and parole. Subjection C states in part that release eligibility, status, and parole shall not apply to or authorize the release of a multiple rapist or child rape prior to service of the entire sentence imposed by the court. Okay, this is law argument. It's too long. Conclusion. The petitioner plea should be vacated because it was made in ignorance of the direct consequences of the conviction, and that it was therefore not voluntarily in the constitutional sense. That the advice and services rendered by counsel arbitrarily undermines the proper functioning of the adversarial system to a point that his conviction cannot be relied upon as producing a just result. That the constitutional mandates of the 6th and 14th Amendment were not followed in the case at bar. That the standards set forth in Strickland and Gates versus United States reveals a crucial role which the adversarial system should accord a defendant pursuant to plea agreements regarding mandatory sentences. Wherefore, the petitioner submits that he should be allowed to serve his sentence with the benefits of parole eligibility to redress the deprivation suffered from the ineffective assistance of counsel, or be allowed to withdraw his plea of guilt. Now, this is the order granting petition for post-conviction relief. Okay. It says here, in the criminal court of Tennessee at Memphis, the 13th Judicial District at Memphis Division 10, Eric Johnson petitioner versus State of Tennessee, P-16501. Order granting petition for post-conviction relief. This cause came on to be heard on the petition for post-conviction relief filed in this matter, and the state's response thereto. It appears to this court, after an evidentiary matter in this cause, that the petition is well taken and should be granted. The defendant pleaded guilty on April 10, 1995 to 2 cases of aggravated rape and received a 15-year sentence on each case, concurrent with each other. The State of Tennessee and the counsel for the petitioner structured the plea in such a way that they felt he would be eligible for parole after serving 30% of a sentence. All parties have agreed that was the intent of the plea negotiation, and the defendant reluctantly entered his plea with that understanding. The petitioners testified that when he arrived at the Tennessee Department of Correction, and found that he would be serving his sentence as a multiple rapist and would not be eligible for parole at 30%. As he understood he entered, he contacted his attorney. His attorney still felt the agreement was proper. However, once the sentence was clarified and the law examined, all parties agreed that the petitioner was not eligible for early release judgment had become final. The clear intent of the law is that a defendant freely and voluntarily, knowingly, and understandably entered a guilty plea based on the testimony and stipulation by the state. The state, the defendant did not knowingly and understandably enter a guilty plea, even though parole eligibility are not normally considered as part of a plea of guilty. In this case, where a defendant enters a plea strictly because he thinks he will be eligible for parole, and the state and his attorney structured the plea so that they too believe that he will be eligible for parole, when in fact he is not eligible for early release. This court feels that the plea was not knowingly or understandably entered. This court does not criticize any of the parties in this matter and finds no fault, but merely a misunderstanding of the law. It is therefore ordered by the court that the petition for post-conviction relief is well taken and should be granted. Due to the seriousness and nature of these charges, the petitioner will remain in custody with no bond until he shall appear before the Honorable Fred Ashley, Judge of Division 6, for purposes of trial setting. The judge on this is James E. Beasley, file 7/11 of 1996. July 11, 1996 is when this was filed. Okay, that was I just showed the petition for post-conviction relief that was filed on February 28th of 1996. And that post-conviction cause number is P16501. And the petition in the order granting petition for post-conviction relief was filed July 11, 1996. I'm going to end this video. In the next video, I'm going to do will be the Shelby County, Tennessee official website, General Sessions Court, and Criminal Court.